you. So I'm Jen Miller. I'm so glad to be with all of you today. It's always an honor to be with all of you. We have quite a few more people registered, so I think more people will be jumping in, which is great. I am excited to have Freda with us, who's so hardworking, and she is appearing now. Hi, Freda, as well as Freda and I will talk for half an hour or so, as long as she gives me, and then we will transition and bring Catherine Terser into the conversation. But first, let's go to the next slide. Just a couple public service announcements. We do have our State House Day, Wednesday, December 7th. We were waiting to decide what we were going to focus on until lame duck. We're now in lame duck. We are hearing that there will be a major, that there'll be hearings, in fact, this week on Senate Bill 294, which has AVR in there, but will have strict ID and some other things. We're not sure yet, so we know we need to advocate on that. We're hearing that we will have to fight to protect ballot initiatives, just the act of putting initiatives on the ballot by the people. So I don't know if that'll come up lame duck or it'll come in 2023, but we want to talk to lawmakers about that. And we, of course, will ask lawmakers for fair maps as well as potentially some other things. So please, please, please join us for that. Next slide. Always remember to join the league. When we do these lawsuits, we do them on behalf of our members. And so being able to say that we have members in all congressional districts, all Ohio Senate districts, and most Ohio House districts really does help us with standing. So please join the league, or remember to renew your membership. And it's the holidays, so this is how I make sure I rose smile, is always make sure to remind you that you could give a gift of democracy by donating to the league. With that, I want to thank everyone for being here, and I want to welcome you, Freda Levinson. So Freda, you and I have been through so many lawsuits together. It's not really my preferred method of doing things. I would rather us be able to get things through legislation or through productive conversations with Secretary of State or others. But let's go ahead and talk about what we got going on now. But first, could you tell us about the legal team? I think that I think our members have been following the lawsuits, but who is the legal team? Who are the experts? Who's working on behalf of voters and specifically the league when we're taking these actions regarding gerrymandering?
Okay, that's a really good question, Jen. And I just have to say, it is my preferred method because it's when you get litigators in there, that's what we do, is file lawsuits. So I love when working with you, and you're an amazing advocate. You're an amazing witness. And when we put our face forward in a lawsuit, it's so good to work with you personally. And we're, of course, work with the league as premier client, because no one enjoys more respect when it comes to democracy and nonpartisan stance and intelligent analysis before taking a position. When the league signs onto a lawsuit, it means that it has serious merit. So it's great to work with you, Jen, and with the rest of you. So when you file a lawsuit, you see me or maybe another lawyer talking to you about it. But here I'm the tip of an iceberg, of an enormous one. You have a huge team of lawyers, especially on these redistricting cases, because they're very intensive factually and legally. We have a couple of lawyers at the ACLU of Ohio. We have a couple of lawyers at the ACLU National Voting Rights Project working on this. And then we have an enormous team of lawyers who are working pro bono from the firm of Covington and Burling, which is a large national, international law firm. I would say that on the two redistricting cases combined, well, actually, there have been 5 cases, but basically they have to do with congressional map and legislative map. So I'll call them 2. There have probably been 40 lawyers working on this, as many as 20 at a time. And when I say working, I mean day, night, weekend, round the clock, intensively at times. So this is a very, very labor intensive case. And we hire experts to work on this. Expert political scientists and computer modeling experts, experts in map drawing, and at any given point, we've typically had about 3 or 4, 4 or 5 experts who we hire. We retain them. They're experts in their field. They're qualified as experts with the court or stipulated to be experts with the other side. And they're working hard for us with sometimes with their graduate research assistants. So you have a very, very large team actually at work on these cases. And paralegals and messengers and communications people and, like the whole thing.
So
this is a big group effort.
Massive machine. Real quickly, why do you prioritize working on gerrymandering? Because I know this is a passion for you and you work on a lot of different things. And so why is fighting gerrymandering important to you personally?
So yeah, we do work on a lot of things with you guys when we work on voting rights. And we work on many rights. The ACLU works obviously on not just voting, but on reproductive justice, LGBTQ issues, racial justice, First Amendment, just the whole gamut. But voting is the most important, in my view, because it's protective of all of our other rights. If you can have a right, you can have a right provided by some piece of paper like the Ohio Constitution or the U.S. Constitution, but it's worthless if you can't enforce it. If there's a legislature that will enact something that violates it and there's nothing you can do about it. So we need to be able to vote and have our votes be meaningful. And the trouble with gerrymandering is, yeah, you're allowed to vote, but your vote doesn't receive equal weight if you're in the disfavored party. So you can vote your heart out. You can have strenuous efforts towards turnout and have a robust turnout and still not be able to accomplish anything. And so it's very undemocratic. And then also, of course, as you know, it leads to polarization in the legislature because when there isn't a meaningful primary, legislators don't have to play to, or contestants don't have to play to everyone. They play to the extremes as a race to the extremes, and then you get polarization and gridlock and laws enacted that do not represent what the people want.
Thank you for that. Okay, so how many times has each district plan, so the Ohio State House maps and the congressional map, how many times have they been struck down by the Ohio Supreme Court? And just real basic, why?
Okay, so this has been like Groundhog Day, this litigation, because we won both cases, both our challenge to the congressional map and to the legislative map. And they were, the court instructed the state to draw new maps repeatedly. And the new maps were challenged for still being unconstitutional. And there's more court process, and the court struck that and was sent back again. And so we've had this same iterative process. The state legislative map was struck. The fourth map was found unconstitutional, but we still were ultimately forced to vote on under an unconstitutional map because, frankly, the state played we were racing against the clock. The clock was on the side of the state, and they fought until we literally ran out of time. The congressional map was stricken twice. So now the state is under orders from the Ohio Supreme Court to produce yet another state legislative map and yet another congressional map. As you know, we didn't get new ones in time for this election in either case, but there's still the maps that are in effect or that were in effect up through this election will not be good for the next election, where the state needs to come up with new maps. in both cases, a new legislative map for the House, the state House and the state Senate, and a new congressional map for our United States congressional delegation.
Thank you. And we're just doing a little groundwork, just a little bit, just because it's hard to follow everything, and we're going to get into some of the meat and potatoes as we keep going here. So thanks everyone for your patience. This past Thursday, there's always this post-election conference called Impact Ohio that I always try to go to, and Nazik went with me this time. And in that, CUP said that both sets of maps were only good for 2 years. Is that your understanding? Because that's confusing, right? Because the Constitution says 4 years, or 10 years. So where does this 2 years come from? What's your understanding of that, and what's next?
Okay, it is only, they're in effect only for this election because something had to give. We have to have an election on election day. So even if a map has been stricken as unconstitutional, if a court decides that there isn't time to make a new one, then you proceed under the unconstitutional map. And that's what happened in both of our cases, is that literally time ran out. So the elections were conducted under maps that, and this is a huge credit to you, League of Women Voters, that were better than the maps that were originally enacted, because we had challenged those maps and we had won. The state made new maps. We challenged those because they still weren't right, but they were better. And we did conduct this election under better maps than those originally drawn. Most dramatically, the congressional map, the U.S. congressional districts. The original map provided 13 districts that were clearly going to go to Republicans and 2 districts that were going to go to Democrats. But as you know, the election ended up with 5, not 2, Democratic districts. And so it was a much more balanced map than was originally enacted. And the legislative map, too, it was incrementally better than the map that was originally drawn. So these are only good for this election. Hopefully the challenge will continue and we will get maps that are completely compliant with the Constitution. But frankly, and I'm speaking very frankly now, we'll need to be making a calculation as what we can do further with litigation, because at the same time we were electing all of these legislators, as you know, we were also electing justices for the Ohio Supreme Court, and the the candidates that prevailed have yielded a bench of judges that have very clearly indicated that they would not have stricken the maps. They would not have enforced the provisions in the Ohio Constitution against the originally enacted maps. So we need to consider our options strategically, as litigation proceeds. But we are still in a litigation posture. The cases are still filed. They're still under orders to produce new maps. And I think Jen wants to go and talk further about what's happening in federal court over our congressional map. But maybe that's another question.
Yep, I think so. So how about first, you told us a little bit, okay, so we now have a Supreme Court where those who just, maybe we want to go down through those numbers, if you will, but what that Supreme Court looks like. We know that the Redistricting Commission itself will have the same basic makeup. It'll basically still have 5 of the majority party and 2 of the minority party. What's the count on the Ohio Supreme Court? You want to just maybe distill that down a little bit more?
Yeah. So as we were litigating these cases, the court was composed of a majority of Republicans, but it was a very closely divided court, and there was one pivotal Republican, the Chief Justice Maureen O'Connor, who actually did not vote along party lines. She believed that the maps were gerrymandered. She wanted to enforce the provision in the Ohio Constitution that prevents gerrymandering. And so she voted to strike the maps. She was term limited out, and a Republican who had voted to uphold the maps won the position that she is currently in. So when the new year comes and the new justices are sworn in, we're going to have a majority of justices who have made it clear, either by voting or by speaking, that they would have upheld the actually by voting in every case, that we'll have a majority of justices that would uphold the maps that would not have struck them as being unconstitutional.
And we will get to next steps. I see people wanting to get to next steps, and we're going to get there, but this is our chance to actually have Freda. So we're going to dig in more to the legal. Okay, so now we have an idea as to how the elections could affect us in terms of the future. What did the elections, these actual results, tell us about the maps themselves, right? So something that Freda and I've talked a lot about is it's actually easier in some ways to litigate against districts that have already gone under an election. So what did these maps, I mean, what did the election tell us, you know, especially looking at the state house?
So, you know, I have to say we're still analyzing this, and I'd hope to have actually some work done for you today that I have not been able to get, and that is to have an expert take the old maps and overlay them over the results so that we could have seen how the election precisely would have turned out under the originally enacted maps. That's a complicated analysis. I've been trying to get it since the day after the election, and I don't have it yet, and I will in a few days. But you know what we had was projections. You know, when you're litigating gerrymandering, you're talking about how a district that's drawn will perform in the future, and you can make pretty good projections. But of course, that's not as good as actual election data when you've just had an election. So we use recent elections, obviously, and now we have one that actually occurred. So I really wish I had that in hand. We can see really clearly though with the congressional map that we had many more seats than the enacted map would have provided. It's hard to assess partisanship in Ohio. I think people political scientists and people that know much more about voter behavior than I do are still talking about this. In Ohio, as opposed to in other states, we didn't really have a referendum on abortion. We didn't really have a referendum on gerrymandering. There were not issues on the ballot addressed to that. People knew what candidates stood for, but that they were voting over, the economy and public safety and other things. The bail issue drew people to the ballot. The non-citizen voting issue drew people to the ballot, and so we had people voting over other things, not strictly. It's got to be teased out and analyzed before we have full understanding of this election. But I think in gross terms, we know that the work that you guys did produced better results than were projected under the original map.
Got it. Okay. Thank you. So still gerrymandered, not as bad as they could have been, which means that our ballot initiatives did provide some protection and relief to voters, just certainly not enough in real terms. So let's keep going. I wanted to ask you about now. Okay, so we had the federal case that was brought by some conservative voters and activists on the state house maps. Now we have Republican lawmakers who have taken the congressional case to the US Supreme Court. Why? What do we expect from that? What's their argument? Help us understand this.
Yeah, so the Ohio Supreme Court ordered the state to draw a new congressional map. And it was supposed to have been drawn in time for this election. The state did not do that. It simply ignored the court. It didn't do what the court ordered it to do. And time went by. It was brought to the court's attention, hey, the state isn't complying. And the state responded, we don't think we have to. We might actually be challenging the Ohio Supreme Court. And they didn't do anything. Some time went by, but then they started to talk about filing a federal lawsuit in the United States Supreme Court challenging the Ohio Supreme Court's rejection of the congressional map. And they ultimately did file in September what's called a petition for certiorari. That's a request that the United States Supreme Court review the Ohio Supreme Court's decision. Now, the U.S. Supreme Court doesn't have to take any case at all. It decides, it takes a small fraction of the cases that it's asked to take. So that's what a petition for certiorari or a cert petition is. It's a request that the court take the case. And the Ohio was asking the U.S. Supreme Court to take the case because they said that what the Ohio Supreme Court did was unlawful under a brand new theory called the independent state legislature theory. I'm calling it a theory, but it's actually just it's that kind of dignifies it. It's kind of an extreme idea that's that only kind of out there extreme conservative writers have written about in recent years, but it has caught on with some of the very conservative U.S. Supreme Court justices. They've written about it in some of their writings on other cases. So it seems to be appealing to the new conservative majority on the U.S. Supreme Court. And in fact, there's a case that is going to be argued in December called Moore versus Harper, coming out of North Carolina, that's putting that precise question before the Supreme Court, the independent state legislature theory. What that theory says is Article 1 of the United States Constitution says that state legislatures determine the time, place, and manner of an election. And the proponents of this kind of wacko theory say that since Article 1 of the Constitution says that state legislatures get this authority to determine the time, state, and manner of elections, that means they and only they get to make these decisions, that these decisions are unreviewable by the state Supreme Court, that they can't be controlled even by any state law. They can't be controlled even by a state constitution. So in other words, the constitutional provisions that you guys worked so hard to embed in the Ohio Constitution, according to this independent state legislature theory, would be stricken as being unconstitutional under the federal Constitution. In other words, the Ohio legislature would be given unfettered discretion to do anything it wants in terms of designing districts. If it wanted to gerrymander, it wouldn't have to pretend that it wasn't gerrymandering. It could say, we're gerrymandering because we're entitled to, we want to. And they could perpetuate themselves in power just as long as they wanted and draw whatever kind of districts they wanted to. Free of review of any Ohio court, including the highest court, free of the strictures of any law, including the Ohio Constitution. It's really a scary law. The implications are terrifying. And, we don't believe that the independent state legislature doctrine is really a thing. Not just, as a matter of public policy, we don't believe that that's the law. It doesn't follow the history of our country. It doesn't follow the text of the Constitution. We're going to be arguing strenuously that the cert petition not be accepted by the court. Our filing is due on December 19th. We're working on it now. And meanwhile, it will be very interesting, I'm sure, for all of us to listen to the arguments made before the court. I think they're on December 7th in this Moore versus Harper case, and to see how the U.S. Supreme Court is going to be regarding this extreme new theory. Even if, I should say, that the Moore versus Harper case is taken seriously by the court, and the court does decide that the independent state legislature doctrine is real and strikes the maps that were drawn in North Carolina, Ohio is sufficiently different. So I think that we have a good chance of still emerging with our constitutional provisions intact. But I just say a good chance. I just don't know. We don't know the extent of how seriously this doctrine is going to be taken, and how what the contours of how it's going to be interpreted and applied. It's very scary.
Great, thank you. And it could affect other things, right? So depending on how, so first off, there's a lot of opposition, right? From judges and states, like Republican and Democrat, right? Chief justices, all kinds of folks, right? There's a lot of opposition. So it is fringe and there is a lot of opposition, but it's also, I think, very attractive to some. So this independent state legislative theory, they could rule very broadly, and it could affect a lot of things. They could rule very narrowly. If they ruled very broadly, what else might it impact beyond gerrymandering?
Many of it would give the state legislature the ability to do what it wanted around elections. They could eliminate drop boxes. They could eliminate early voting. They could mess around with the other aspects of the calendar, and who can vote, with regard to who can register, and voter ID requirements. You name it. It would keep you guys very busy, as if you're not busy enough. But it would disable you. You wouldn't just be busy. You would find yourself in a war without any weapons. So
it's our hope that they will completely, not rule, find that the ISL has any rule at all, in this realm, right? But also, if they do, that it's as narrow as possible. So thank you for that. We're going to switch now and talk about, could the Ohio Supreme Court reverse any of its decisions? And since we have these open cases, do previous decisions stick, or can they reverse things?
So a court doesn't just do something on its own. It requires a case or controversy brought to it and an opportunity to render a decision. So, if something is brought again before the court, and it's likely that it could be by either party, because we have these live cases, then it would have an opportunity to rule on what's brought before it. And it's, given how we understand the ideology of the new court to be, they could find a way to narrow or limit the rulings that have been made, or even they could reverse them. I mean, we do operate in a justice system that depends on precedent, stare decisis, predictability, and consistency of the law and interpretation of the law. So we all have an understanding of what the law is based on how it's been applied. But the new norms, look what happened to Roe versus Wade in the U.S. Supreme Court, where the court took existing law, existing understanding of what our Bill of Rights does in the realm of reproductive justice and privacy, and they said, oh, we've read it wrong for the past 50 years. We're changing it. So, I don't put anything past, I wouldn't say that anything's impossible. I think it's possible we could have these, a new, different, opposite interpretation of the Ohio Constitution at some point by this court.
Thank you for that. We've got lots of questions. One thing that So we've got saying OHGA. So I guess the Ohio General Assembly would likely bring a case against previous decisions. Do you expect that the General Assembly might actually bring their own case against previous decisions?
No, I would imagine it would be an appeal with, not an appeal, but a new filing within one of these cases, maybe a motion for reconsideration or something. I don't know exactly what the vehicle would be, but I don't think they would bring a challenge. I don't see that what they would challenge other than working within these cases.
If you had a magic wand and you could just right now today have a new constitutional amendment in the Ohio Constitution that had to deal with redistricting, what would it say? Just out of curiosity from you, because this is part of what we have to do now is ask lots of folks next steps.
So if we had an amendment in the Ohio Constitution that was too muscular, that allowed the Ohio Supreme Court to say, draw its own map, or appoint an expert or to draw a map, we would have had a better result in this case, but we would have risked running afoul of the independent state legislature doctrine. So right now we're in a kind of a new limbo where you'd want a magic wand that would control the U.S. Supreme Court and also control what goes into the Ohio Constitution. We're going to have to see what the court does with this. It seems like the amendment that was passed was weak in the sense that it didn't give the court the muscle to force a new map in time, but maybe it hit some kind of sweet spot because it also didn't risk violating this potential independent state legislature doctrine. I don't know.
You're basically
we'll know
saying,
in the future.
if I hear what you're saying that we're all frustrated because they kept striking down the map and maybe there weren't more tools in kind of the Ohio Supreme Court's tool belt to really hold these map makers accountable. But on the other side, if the Supreme Court had made its own district plans, that might have landed us before the Supreme Court of the United States faster with this independent state legislative theory. Is that what you're saying?
Correct. Yes, yeah. Very well said. And also with a different result, we'd be more like North Carolina. Still not exactly like North Carolina because the language of the North Carolina Constitution is different and not as good as Ohio's. But what the court did there was to draw a map, and our court restrained itself. Our state Supreme Court restrained itself. But I mean, here I think we should be careful what we wish for. I think we need a little more data before we wish.
Okay. Well, and I just even meant like abandoning this system at all together, but I would like to bring in our friend, Catherine Terser, to see if she has any questions for you, Freda. And then people are hungry to talk about what's next, which is one of the things I love about our Fair Districts advocates and our league members is that we are tireless, right? We are not going to give up. But Catherine, what questions do you have for Freda?
So the one that I get fairly frequently, and this tells you what kind of nerds I'm hanging out with, but folks are really interested in like the representational fairness criterion or like the proportionality criterion, whether because it's 10 years and it was 10 years in 2021, but it could be map making in 2023. Does that change the criterion, or is there an understanding that we're talking about the previous 10 years before the receipt of the census data?
Yeah, that's a really good question. I don't know that that we necessarily know the answer. I guess that's something that could be argued either way. It could be at the time the map is drawn, or at the time that the census data is received. It doesn't say certainly in the amendment, and I could see partisans each taking a different side, because obviously if Ohio is getting redder, as people say it is, then of course Republicans would want the later snapshot in time, and Democrats would want the earlier one. That's something to be litigated. Yeah, that's a nerdy and fascinating question.
Well, and it's interesting to go broadly. one of the things that a lot of us just keep hitting our head against is like, well, why isn't gerrymandering just unconstitutional? And I think it's worth kind of going back and explaining to folks just like, well, all right, we have this weird independent state legislature theory, but how is it that they never just decided, Rucho v. Common Cause, like what happened there, just so that we're even here can be helpful for folks?
Yeah, that's a really interesting question, because you know that you guys, the league, also litigated gerrymandering several years ago, before these Ohio constitutional provisions were in effect. We were challenging the previous congressional map, the one that was in effect over the last decade. And we litigated in federal court under theories that this violated equal protection and due process and freedom of association under the federal Constitution. And we sued in federal court, and we won after an 8-day trial before a 3-judge panel. Again, just a huge production, huge undertaking. And they determined that Ohio's map was just infected with partisanship that violated the United States Constitution. And at the same time, as Catherine just mentioned, there were a few other cases going on in other states. A couple of them were in the pipeline ahead of us in Ohio, and they hit the Supreme Court because these were appealed as of right to the U.S. Supreme Court. And one of them, Rucho versus Common Cause, Catherine's organization, the U.S. Supreme Court decided, yes, this state, the state in Rucho, was gerrymandered. Yes, like it seems to violate these provisions in the Ohio Constitution, but this is actually a political question, not a legal question, and U.S. courts are not equipped to determine political questions. So we are going to reverse and remand this case back to the state, and we are saying that the federal courts are not open to questions of state gerrymandering. If there's a solution to these cases, if there's going to be any judicial redress at all, it lies in state courts. State courts and state constitutions are going to regulate gerrymandering. It's not a federal question. It doesn't belong in federal courts. So this time around, when we challenged the current map after the recent census, we didn't file in federal court again. We were told those doors are closed to us. We filed under the Ohio Constitution only in Ohio, the Ohio Supreme Court, just like the U.S. Supreme Court told us to. They said, this is where you go for to address gerrymandering. And now, as Catherine has pointed out, we're coming back to the U.S. Supreme Court that's going to say, actually, bait and switch. The federal courts are closed, and so are the state courts. You guys just have to tolerate, suck it up, and live with gerrymandering, because federal courts don't decide these questions, and state courts have no authority to tell state legislatures what to do. That would be like an unbelievable answer, but this is what we're looking at here.
So I think there's lots of people that want to know about, are we going to do another constitutional amendment? We're going to do other ballot initiatives. Yeah, Kathleen, you're right. That was just decided in 2019, where the U.S. Supreme Court said that gerrymandering was unjudiciable. And now here we are with the U.S. Supreme Court, which is why I think we all know skeptically that we really got to watch the Ohio Supreme Court too, that we have lots of room here. So of course, our folks want to know about ballot initiatives. So my first question to you, Freda, is do you feel like it is, should we be watching what the U.S. Supreme Court does as we think about crafting a new ballot initiative campaign and that language?
Yeah, I mean, certainly that will be on your mind. You've got to look at the landscape that you're operating in. I think we've learned a lot from this litigation about what a lack of power on the part of the state Supreme Court, means. We've seen what tools they could have used, and we know as a practical matter how we could have gotten a faster and stronger result. But we also have to, watch and be wary once we learn more about whether or not there is a independent state legislature doctrine. That's an open question. And then, if there is, what are the contours? And let's keep that in mind as we craft the language.
So Catherine, do you want to talk about kind of what we're thinking? And then Freda, we would love to hear your response to this. We are very early in kind of thinking about a constitutional amendment, but what are we thinking about, Catherine?
So, one of the things that I want to highlight is I want a clipboard really badly. I want to have an activity to do. And I want to, direct democracy is so important. That ability to change the Ohio Constitution is so important. It is one of the only tools that we have right now because, our legislature is dominated by one political party. And so I am frustrated by how slowly things are moving. And yet, we are very slowly doing research, talking with people, thinking about the very weird legal landscape that we're in. So, one of the things, Mike Curtin asked a question, and it had to do with do you like Iowa's model? Do you like Arizona's model? So, one of the things I've always really liked Iowa's model, for example, which really focuses on giving the map making to an independent body, right? And fortunately, their legislative service commission draws the map. Unfortunately, for us, having this entity draw our maps might not quite work as well because, of course, they work so closely with legislators. Over time, some have become more partisan than others. So I'm not completely convinced that the Iowa model will work well in Ohio. When we look at Arizona, they have an independent redistricting commission. It's made up of citizens. It is a small number of citizens, including Democrats, Republicans, and independents. But what can happen there is there's with only kind of one swing vote, things can get a little complicated, and you don't get kind of the diversity of opinions that you get, for example, from Colorado, or if you think about California, or for that matter, our neighbor Michigan. So we're kind of looking at what is a sweet spot for the number? And so, are we talking 15? But because that can be a little unmanageable, but 5 is too small. So those are the kinds of things that we're thinking about and doing research into. And if any of you who worked during 2017 on map making collection, I don't know how many of you visited me in Petition Central, where we had no air conditioning in the summer. And we really had no good heat in the winter. We weren't freezing, but we had no money. and I was glad for all the
walked uphill both ways to the office. I was
going to say, not just collecting signatures, but doing the process of preparing the petitions and all of the things that we all did together. But we should know going in, to think long term, we need to be sure we have good resources to move forward. And so part of the planning process is not just thinking through, what are the details? It's not just thinking, okay, what is the big picture? It's not just, what works in other states or didn't work. And for example, in December, we're going to be hearing from a commissioner from Michigan. His name is Anthony Eade. And so a young guy who is a medical student who got on this board. So I think that will be very interesting. That's in December at the Fair Districts Volunteer Huddle. So I encourage you all to participate in that. But all of these different things that are all come together to make it so we're all just moving super slowly.
Yeah.
And we should feel comfortable with that. We want to do this in a really thoughtful way.
Yep. I think we will. Michael Barron says, can we inspire the legislature to move again, potentially. But my whole thing is like, I don't want to stand still. I'm okay with moving slowly and deliberately, but I don't want to stand still. So Freda, since we have Freda, let's just ask, like, which pieces of this, so you talked a little bit, but like, let's talk about the gerrymandering criteria itself. I think we're talking a lot about how we would change who makes the maps, that actually politicians making maps is just too tempting for them to do themselves favors and their friends favors. But out of like kind of the other language about how we might measure or prove that that maps are partisan unfair, would you keep pieces of that today?
Yeah, that's not the part that was broken here, right? That worked for us. I thought that there was a question at first, as you recall, when we began to litigate, whether the gerrymandering criteria was aspirational or whether these were actual requirements. But once the court decided that these are actual enforceable requirements and that they apply, the terms of them, appeared to be useful to the court in issuing orders. It produced better maps. I think the tool that was missing wasn't the criteria for the maps, but the enforcement mechanisms. I mean, as far as we tested, as far as this experiment, this litigation tested, what ultimately didn't result in perfect maps was because the court couldn't get the Ohio to draw better maps in time. It yielded. It only had this iterative process where the court could only say that one's not good enough. It has these defects. Try again. Look at the next one. That one's not good enough. It has these defects. Try again. And the map drawers came up with new maps every time. Sometimes they corrected some things, and other times they passed the exact same map again and just turned the same map back to the Supreme Court and burnt more time with that. Or they made superficial changes and handed that map back to the court. And the court lacked any power to say, no, we're going to fix this and fix this. All they could say was, no, try again. No, try again. And so that was, until the clock ran out. So it was more of a court authority problem, I think, that led to the result that we had here. On the other hand, that could have been the saving grace if it preserves our amendment from being stricken under the independent state legislature doctrine. Because it could be that the U.S. Supreme Court decides, yes, there's an independent state legislature doctrine. We do subscribe to that. That's a theory. That's a thing. But what it means that, a state court can't just take control of the redistricting process. That belongs to the state legislature. And we think perhaps that was violated in North Carolina. But Ohio, according to the way we view that, the legislature actually had a hand in crafting these provisions that were embedded into the Ohio Constitution. And these provisions, are authorized, delegated the power to review maps to the Ohio Supreme Court. So this stands under the independent state legislature theory, because the state legislature decided to do it this way. They said to the court, you can review these things. You're not going to draw a map, but you will review them for us. So, maybe this will save us. Maybe this will give us some guidance when we draw, if we pass clipboards around with, some new language for a new process. Maybe we need to think about, less about the criteria and more about the process, to make sure that we don't violate whatever the court, whatever SCOTUS says are the new lines that we have to think about.
Great, thank you. We only have a couple minutes left, so we have lots of questions. We have the long term, which is that, yes, we are doing research and we are thinking in the long term what we need to do to change the Constitution. a plug again for State House Day, which is December 7th, because we do anticipate, if not during lame duck, next General Assembly attempts to make the petition process harder. So one of the first things we need to do is really protect ballot initiatives in that process and keep it, you know, as a tool that we can use, because we know it's a powerful one. So that's our long term, is really looking at the ballot initiative. One of the shorter term things is defending that process. What's one of the short term things? You know, I think this is a really great question from Laura Joseph. What are our constraints in terms of, you know, what's next? You know, what can we all do together before the next election, you know, before the next maps that we vote on? What are the kinds of things we should be doing? And so I know that we have this brilliant legal team that will be continuing to do their work. Catherine, what kinds of things are we getting ready to do at fair districts once mapping starts again?
So this always becomes a little bit complicated. I don't know about you, but listening to Freda go through, you know, the Ohio Supreme Court that we're going to have, the leaders that we have, going into this map making, and trying to think about, well, what can we do differently? What can we possibly do to like influence the process? Well, I do think we need to be super creative about that. We do need to prepare for serious pushback if they try to change direct democracy, because if they make it harder for us to do citizen initiatives, you know, that just takes away just an incredible tool that we have right now. I noticed Mark Salling throwing out this idea. So this is, you know, Professor Salling throwing out an idea about a competition. And this is very similar to what Joan Lawrence recommended for years and years. It's very similar to the 1981 a citizen initiative that was not successful. I do think it's super interesting to think there are a lot of different ways to make this so that we can engage more voters. So one of the things that we can all do is participate in this kind of what makes sense. And that notion of thinking through and talking with people about, well, what is it that we can actually do together? Like, you know, how can we actually influence this process in a different way? And we have, you know, we've testified and we've done postcards and we've had rallies and we've done marches. And so we need to be thinking about, well, what else could we possibly do during this process? And a modified kind of competition, which we also did, could be super interesting. Like it could be a way like to demonstrate what is better and what could work better, and just to highlight, you know, these people are drunk on power. They're drunk on power. They're not paying attention to the Ohio Constitution. And whatever we can do to make it super clear to the public and educate the public so more folks are actually with us, make an enormous difference, not necessarily in the short term, but will make a difference in the long term.
So Mary is asking what kind of competition. So Mary, we and Joan Lawrence is on today, and so we've done this a few redistricting cycles now where we have invited general members of the public to create maps and submit them, and those were reviewed by a diverse panel of experts and selected to be the maps that Fair Districts Ohio presented to the General Assembly and the Ohio Redistricting Commission. I think we'll be doing that again. Here's what I'm going to say. Lots of good ideas, lots of passion. I want to honor these two redistricting divas, two of my favorites, along with Joan Lawrence. Catherine and Freda, will you please come back and hang out with us again as we see some more things moving? You promise you'll both come back?
Well, we will definitely come back. And then there are so many folks that are actually part of this webinar that you should also invite, because I would love to learn more from them too.
Well, and you know, one of the things I will promise that we did in the past was we would actually put up the language that we thought we might use. We would share that widely for input. So you'll be hearing from us about the design of things, but know that there's so many other pieces and parts, and we are here short term. As early as December 7th, we're going to be descending upon the Ohio State House in numbers, talking about the value of ballot initiatives and why we're going to go ahead and ask them to make better maps. The medium term, we have these lawsuits, and we have the ability to promote another mapping competition and those things. Long term, changing the Constitution. But thank you everyone for joining us, and we hope to see you soon. Thank you. Bye-bye.